Item number 1.
May I please, Your Lordship? Yes. But, my Lord, if my Lord may kindly produce page number 140, my Lord. This judgment passed by my Lord. The last paragraph. If I am permitted to read, my Lord, let the writ petition be treated as a petition for the review under the instruction 162D and be tendered before the state government, which shall within 90 days of receipt of this paper, upon hearing the appellant, writ petitioner and other interested parties, and by a reasoned order decide the question of bifurcation of the appellant village, namely so and so, my Lord. My Lord, here, my Lord, only thing is this, my Lord, it cannot be a state government. It is the district council, my Lord. We have adopted Assam Land and Revenue Regulation, my Lord. And
please take out the instructions.
My Lord.
Give us a copy.
My Lord, may kindly see appointment of governors. This regulation has been adopted by the district council, my Lord. My Lord, may kindly...
No, please see.
My Lord.
If there is any grievance,
my Lord,
against appointment of Goan Bura, etc.,
my Lord,
or termination of his service,
my Lord,
it is from the deputy commissioner to commissioner,
my Lord.
Then the ultimate appellate authority is the state government.
Yes, as per the instruction,
Yes.
my Lord. But
since you've been traveling from pillar to post,
my Lord,
within these authorities,
my Lord,
commissioner, deputy commissioner, assistant commissioner, etc.,
my Lord.
so we have relegated the matter to the ultimate authority. Let them decide.
Only thing is this, my Lord, the state has no role because we have adopted.
You give us the instruction, we will show you.
My lord, this is the instruction, my lord. And if my lord may kindly produce the green book, my lord, of the district council, where we have adopted the Assam Land and Revenue Regulation, my lord, and section 3 of that adoption says, my lord,
You have another copy?
no, my lord, I don't have, but
You give him this.
my lord may kindly produce.
No, we have seen.
Green.
We have given a thoughtful consideration.
My lord.
Please give him. 162D.
My lord, I've seen that, my lord. Only thing is this, what I am submitting, my lord. We have adopted the Assam Land and Revenue Regulation, and the state government is equivalent to the EC District Council, my lord. If my lord may kindly produce the green book, my lord, Assam Land and Revenue Regulation, which we have adopted, the District Council has adopted. As per that, my lord, it is the EC of the District Council who will decide the appointment and bifurcation, my lord, not by the state government, my lord. Because state,
Show us.
my lord, green, kindly keep the green book. Page number 103, my lord. If I, lord, may only peruse section 3, clause 2, my lord. All reference to the state government, commissioner of division and director of land record, or the deputy commissioner, Assam Land and Revenue Regulations and rules made hereunder shall be considered as reference to the district council, the chief executive member, the executive member authorized by the district council respectively.
This is in Garo. This is
In Garo Hills, my lord. All appointments of the Gavuras are made by the district council of Garo Hills Autonomous District Council, my lord, since we have adopted this, my lord. And state has no role, my lord, because land, we are the custodian of the land record, my lord.
who is
But
the
notice has to go, my lord, in this.
notice has to go.
Yes, my lord, notice has to go, my lord.
We can correct this under 152 of the CPC.
My lord. My lord. There's no difficulty on that, my lord.
Because this is something where the other side is not needed.
My lord.
It's only instead of state government, it will be district.
Yes, my lord. That can be done, my lord.
Yes, we treat this application more as one under section 152 of the Civil Procedure Code than an application for review. Paragraph. Paragraph. Let the phrase quotation state government in the second last paragraph of the judgment and order dated
11/7/2025.
11 July 2025 be replaced by quotation District Council. No, it should be Garo Hills Autonomous District Council. Replaced by Garo Hills Autonomous District Council.
To be more specific, my lord, if it can be Executive Committee, Garo Hills Autonomous District Council, my lord.
Why?
Because it is the Executive Committee who will decide, my lord. It's like a board, my lord.
No, the regulation does not say so.
It doesn't speak, my lord, but it is
No, we will mention what is there in the regulation.
My lord.
In terms of Garo Hills Autonomous District Land and Revenue Regulation 1954. Adopting the Assam Land and Revenue Regulation 1886 and the rules made thereunder, with some modifications.
My lord.
The next advocate on record for the appellant. We will transmit all papers of the case to the council within 10 days
My lord.
from date. Then that will remain 90 days of receipt of the
My
papers.
lord. My lord.
This application is disposed of accordingly.
Highly observed.
Number 2,
In the second line you write, no notice to any party is required as the correction is being made. No, the last paragraph. No notice to any party was required as the correction in the order dated 11 July 2025 has been made on the court. Discovering the above mistake in its order. That's all.
number 2,
My lord, in this appeal, my lord, 46 days delay is there to prefer this appeal, my lord. In fact, the other connected matter also, lordship has taken up the matter and fixed on, my lord, 8 August. It's similar matter. It's a tender issue, my lord. I was one of the...
Delay was condoned.
In that case, delay has been condoned, my lord. In my case, 46 days delay is there, my lord. So if lordship kindly issue notice to respondent number 4 with the private respondent number, who is the appellant in that treat appeal?
No, in a similar appeal, delay has been condoned.
My lord, similar appeal condonation has been allowed by my lord. And in my case, my lord,
When is that appeal posted for hearing?
posted, my lord, on 8 August. 8 August. 8 August.
Yes, please.
My lord.
May it please
We
your
take
lordship.
together, my lord.
Lordship, similar appeals are pending, your lordship. It's coming on the but
One thing here, Your Lordship, there is a delay, Your Lordship. The explanation in my humble and respectful submission, Your Lordship, is not satisfactory, Your Lordship.
Satisfactory.
Not satisfactory, Your Lordship. If Lordship kindly have the
But
application.
Mr. Sulai, it's only 46 days. Why object to that? Because of 46 days, the merits cannot be gone into.
Lordship, but there are private respondent also. Our respondent number 4 is a private respondent. Number 4 is the appellant in that induced writ appeal, Your Lordship, which is coming on 8.
And in this appeal,
He is opposite party number 4, Your Lordship. In this appeal, the appellant in those appeal which are coming on 8, Your Lordship, is the respondent in this writ appeal, Your Lordship. Lordship, in that there are three writ appeal. Writ appeal number 44, 45, 46, Your Lordship.
but similar issues involved.
Lordship, against the common judgment, Your Lordship. 3 writ petitions were filed, Your Lordship, by a common.
So one aggrieved party is the appellant in that appeal.
Lordship, yes.
He is also aggrieved.
Yes. I
Yes,
also-
Your Lordship. Yes.
He is respondent number 4 there, but appellant here.
Yes.
No, no.
Yes. Lordship is correct.
Lordship,
is correct.
But
Yeah.
who's the beneficiary of the order?
But both the present appellant and the present respondent number 4 were the
The
beneficiary, in
tender
fact. Both of were the successful tenderers, my lord.
The
And when
tender
the
process,
allocation
Your
for
Lordship,
the allocation of the work,
voiced, Your Lordship, and the state has been directed to float a fresh tender.
so what happened, my
But
lord,
the appellant
in the
is-
tender, both the appellants has been selected as a successful tenderers. So when allocation of the work comes, my lord, government has allotted 75% to the respondent number 4, and whereas to me only 25%. My lord. That was a grievance I made out before the learned single bench. And so learned single bench appreciate that position, that action is wrong. That action is wrong. My lord. But on other ground procedural requirements, learned single bench direct for fresh tender process.
Lordship, yes.
And that is
So both are aggrieved.
both I
Lordship.
agree.
But in fact, I was awarded 75% of the work, my lord. He was awarded 25% of the work. Third parties whose technical bids were rejected, they challenged the tender process,
Tender
my lord.
process.
A bidder whose tender was rejected on technical grounds, my lord, he challenged the tender process, and the learned single judge set aside the entire process, my lord, and directed for retender. Against that order, because we were the beneficiary of the
You are the appellant in the other appeal.
Lordship.
3 appeals are filed with us.
So all the more reason to condone the delay and hear the appeals out.
That's all.
Mr. Sulai, learned senior government advocate. Yes. AG, yes. Learned additional advocate general appearing for the respondent state submits that the delay of 46 days in preferring the appeal has not been adequately condoned. Paragraph. We find that an appeal on an identical issue where the appellant herein is respondent number 4 has been admitted and is posted for hearing on when?
On 8,
8 August.
On 8th August. The appellant herein is also similarly aggrieved by the impugned judgment and order. Which has cancelled the tender for a project made by the appellant in this appeal and also the appellant in the connected appeal. Next, while hearing out the other appeal, we have to go into the merits of the matter. Moreover, the delay in preparing this appeal is only 46 days. Hence, we are of the view that the interests of justice would be subserved if this appeal is also heard out on merits, along with the other appeal on condonation of the delay. Paragraph. Delay in preparing the appeal is condoned. We direct this application under Section 5 of the Limitation Act 1963 is allowed. We direct the registry to register the appeal. Paragraph. Let this appeal be heard out on the existing papers.
Yes.
Lordship, yes.
Along with the other appeal, give the number.
Lordship, 40,
Writ appeal number 44, 45, 46 of 2025. 3 appeals in spine. 3 writ appeals.
3 appeals.
Yes, ma'am.
So that will be in the first paragraph. 3 appeals. Please read out the first paragraph. Identical to. Then 3 appeals. On an identical issue. 3 appeals, bracket, give the number. And then subsequently mention appeals. Said 3 appeals, sir. Yes.
highly apply, Your Lord.
Number 3.
My Lord, this matter, the SLP, my Lord, which was supposed to be taken up on the 16th of last month. So it was a holiday for summer vacation for Supreme Court. So matter will be listed again on, my Lord, tentatively on 6th of next month. So I humbly wait for deferring the matter for today.
Shall we take it up or not?
Lordship, that especially before the Honorable Supreme Court is against the order passed by this court in allowing the implement application filed by the state.
Appeal matter.
In the miscase, Your Lordship. In a miscase. Because what happened, Your Lordship, the contention of the state is that those people who have donated the land in favor of the project taken up by the state have not been made the parties in the writ petition. So in our submission, Your Lordship, is those people, they are a vital party, Your Lordship. They are the necessary party in adjudicating the matter. So that has been allowed, Your Lordship. So against that, they went to Supreme Court.
Well, an exchange of pleading has been completed before Supreme Court and fixed for hearing. In fact, notice has been issued to those private respondents also, my Lord.
What has the learned judge held? What has the against which you are preferring this appeal?
No, this appeal has been filed by the writ petitioner, Your Lordship.
We filed the SLP for Supreme Court. We are the petitioners.
And this one?
Here also we are the appellant here, my Lord. We are the appellant.
You've done both.
My Lord, what happened in this case, learned single bench partly allow my writ petitions. aggrieved with, my lord, we prefer this appeal. During the pendency of this appeal, state has conducted a survey to ascertain whether the land is under submersion by the dam or not. So they have given a report that the land is under submersion belonging to the appellant. Now, subsequently, my lord, the state government came up with the application for implementation at the final stage, and that was considered in their favor. Aggrieved with that, we prefer appeal. Supreme Court issue notice. State has filed an affidavit in detail, and met this.
No, the same party has filed the SLP and the appeal.
Yes.
Lordship, yes. Against the order allowing the implement filed by the state.
How can you do so?
My lord, we are the writ appellant. Our writ petition was allowed by this learned single bench partially. My lord, however, a time frame was not given for acquisition after that. So we prefer this pending appeal where lordship has seized the matter. During that time, my lord, government has complied with the single bench order and conducted the survey and given a report that the land is under submersion. During that time, my lord, government came up with another application again, saying that no, there are four headmen were not implemented in the writ petition as well as the writ appeal. Therefore, they should be made as a party. So that application was considered by this court, and this court has considered that one in there, say that notice should be given to those people, headmen. Agree with that, my lord, we prefer a specialty petition. The specialty petition was, my lord, notice was issued. Direct all the parties to file pleadings. Pleading has been completed, my lord, and the fixed for final hearing effect. And if I may just place a few the order sheets.
No, your writ petition.
Yes.
No, in your writ petition, the impugned order was passed.
Yes. No, my lord, writ petition, my lord. Writ petition was partially allowed, but we are aggrieved with the certain observation of the court, the single bench. Therefore, we filed this present appeal. But this is a writ appeal, my lord, against the challenging the single bench order.
No, your application was allowed. Then what happened?
Application filed by the state. When my lord sees this writ appeal is pending, state government filed an application for implementation of other four headmen. We resisted that one. They filed that implementing application in the writ appeal, in this very writ appeal. We resisted that prayer. However, this order court allowed that application. Against that, SLB is preferred and pending and listed for final hearing. It will be listed. State has filed a detailed affidavit before Supreme Court. So my humble prayer, my lordship, defer the matter in this after 15th of next month. But we are hopeful that the matter may be considered finally by the Supreme Court.
This is a project of 10 crores, Your Lordship. 10 crores. And if we are to pay compensation, Your Lordship, as demanded by them, Your Lordship, that also on the land donated by the village authority, we have to pay around 100 crores, Your Lordship. That is why we have filed an application, Your Lordship. We would like to abandon that project.
Well, the second two writ petitions were filed initially, and the state never take the plea that the certain land has been donated by the one of the petitioner. They never made the plea. Well, and thereafter, my lord, the single bench passed an order. They did not file an appeal. Rather, they complied with the single bench direction, conducted the survey, and the land has been ascertained that yes, the land of the petitioners are under the water, and therefore, the single bench directed them to acquire if the land is under the water. And finally, they came up with the misapplication for implementation of those four villages.
There was an agreement, Your Lordship, and the writ appellant here
That was never argued.
was one of the signatories to that agreement, Your Lordship,
was never argued.
donating the land.
That was never argued before single bench.
If Lordship, can you have the memo of appeal, Your Lordship, at page 228, Your Lordship? That was the agreement.
Well, I'm sorry, my lord, I don't know what is the grievance of the state. They have filed a detailed affidavit for Supreme Court. If they don't want to contest before Supreme Court, they could not file.
And to the left, Your Lordship, down below, Your Lordship,
There is any stay by the appellate court.
no, there is no stay, Your Lordship. There is no stay. So far, this proceeding is concerned, there is no stay from the Honorable Supreme Court, Your Lordship. Lordship, even that was also the submission of the learned Advocate General on the last occasion. That is, it has been reflected in the order dated 16/7/2025, Your Lordship. Where is my? I have it in my. Give it.
Well, in fact, the matter was fixed on 16 July last month because of the summer vacation. Matter could not be listed. So we're expecting that matter may be heard on 6th of next month.
We can hear it out subject to the result of the Supreme Court appeal.
My lord.
Admission of SLP is pending.
In fact, my lord, it is exchange of pleading finished and fixed for hearing, in fact.
Sorry?
Fixed for hearing, my lord. It will be listed for hearing. I just placed the last order after this.
No, it is in the list of the Supreme Court.
My lord, tentatively, my lord, we have downloaded the list, my lord, the first page. My lord, can you see? We have downloaded in the morning.
Yes.
My lord, the first page, I just marked it, my lord. In the middle, tentative case be listed on, likely to be on 8/9, my lord. Is it completed? And the second page, my lord. Second page was the last order.
Give me one.
Yes.
And the second page was the last order passed on 12th, my lord. 12th this November, December, my lord. In the paragraph 4, my lord. Time is granted respondent 1 to 13 to file their reply within 4 weeks from the day. 1 to 13 are the state's respondents. Accordingly, they filed their affidavit in the month of April and matter is fixed for hearing.
It's in the list.
But this is it.
What number is there?
But this is tentative lists are generated from the computer, from the registry only. So normally, if the number is, my lord, the SLP number on the top, it is mentioned. So this is a tentative date where Honorable Court may likely to take up the matter for hearing. So my profound respect for the submission, my lord. Matter may differ.
With reference to our order dated 16 July 2025, and the special leave is with reference, please read out. And the orders passed. And the orders passed therein. Next, ordering, and the orders passed therein. Mr. Lam, please read out. No, order dated, whose order? Is dated from above.
Reference to the order dated and the orders are dated.
You scratch it out. Be referred to our order dated 16 July 2025. And we refer to order date 16 July 2025. Okay. Full stop. There is reference therein to a special leave petition from an interim order in this appeal pending before the Supreme Court. Due to its pendency, we adjourned this appeal by our order dated 16 July 2025 till today. Paragraph. The special leave petition is still pending. Paragraph. We are of the view that there is no impediment in hearing out this appeal, which is from an interim order in the writ before the Supreme Court, comma, as that would finally dispose of the main writ petition Stop. List this appeal on 20th August when we shall proceed to hear out the appeal, subject to the outcome of the special leave petition before the Supreme Court, comma, if still pending on that day. How long we will keep it pending? Mr. Nan, just read out the order. We refer to the order dated first line.
And we'll have to take.
No, special leave petition together with an application for interim relief. Carry on.
Eventually, we adjourn this appeal by our authorization 15 July 2025 to today. Therefore, the special leave petition is still pending. We are reviewing that there is no opinion in hearing of this appeal, which is from the interim from the appeal before the Supreme Court. After that, we'll find it before.
No, which is an appeal from an interim order passed in the writ.
Before the Supreme Court, that will find it disposed of the main petition. This is appeal on 20th August 2025, where it shall hear the appeal on matter subject to the outcome of the appeal before the Supreme Court is still pending on that day.
Yes, call the list.
Item number 4.
Apply.
Enter. It's a conviction, my lord, under section 302, my lord. If lordship permits me, some accommodation may be given to me, my lord. I have some personal difficulty to place the case today. It's a life imprisonment awarded by the learned session judge, no more.
Yes, call the next matter. To Justice, thank you list. This.
My lord, it is listed before the appropriate bench today.
Sorry?
It is not required to be listed before my lord and justice. Thank you. It is listed properly today.
No, which one? The
Hearing number, item number 5.
item number 4.
Your partner.
Pass the order. Justice, thank you list.
Item number 4, lordship has passed the order.
Yes, number 5 is ready for hearing.
5 is ready for hearing, my lord. The conviction matter.
You are ready?
No, Lordship. Lordship, to conduct a counsel, PP is under some difficulty, Lordship. She had to leave.
Before B, you are the conducting counsel. Why you point at conducting counsel, conductor? When you will be ready to do the matter, you say.
Lordship.
Next Monday. You get ready to do the matter. 1 or 2 criminal matters also should be disposed of by this bench.
Lordship.
By consent of learned counsel for the parties, this appeal. Paper books all that is complete.
Lordship.
On 20th August.
Obliged, Lordship.
Yes.
Number 6.
Appeal and miscellaneous application.
May it please your lordship.
Yes.
Milord, if I may take your lordship to the order dated 19th of March, Milord.
No, this is a criminal appeal.
Criminal appeal, Milord.
Ready for hearing.
Milord, it was already heard and I had, my submissions were concluded. That's what I was taking your lordship to.
What is the subject matter?
Milord, it was a murder, Milord. Murder appeal, Milord. Conviction in murder case. So, Milord, the order dated 19th of March, Milord, indicates, Milord, that I had concluded my submissions before the previous bench, Milord. But after that, because of the change in the roster, Milord, the matter has come before your lordship.
The hearing took place in a different bench, my lord. So this request to be heard again. That is.
No, whatever, I'm just indicating to your lordship.
There was part hearing of this matter before. Another bench. Full stop. In March last year.
2025 million. 19th of March 2025, hearing was concluded.
Thereafter the bench has released the matter. It's not taking up.
No, Milord, after that there was a change in the roster. Because of the change in the roster, the matter has come before.
Then it should be heard by the same judges if it is parted.
It has been concluded. My submissions were already concluded. My friend was to submit. I would submit, Milord, if it is heard by the same bench, that is.
Bench comprising of Justice, thank you, and Justice Bhattacharjee.
Justice Dingdo and Justice. His Lordship Justice Dingdo
Yes,
and Justice Bhattacharjee.
yes. Of brother, Mr. Justice Dingdo and Justice Bhattacharjee. In that view of the matter, this appeal should also be heard by the same bench. Let steps be taken accordingly. Yes.
7 and 8. May I please, Lordship?
Yes.
Lordship, this is an appeal against the judgment and sentence passed by the learned Sessions Judge, Your Lordship, in July. However, Your Lordship, I'm praying for short accommodation, Your Lordship.
Appeal is ready for hearing.
Yes, Your Lordship.
Criminal appeal.
Yes, Your Lordship.
All right. This criminal appeal is ready for hearing. Learned counsel for the appellant. Press for time. When you want it?
Your Lordship, after 2 weeks, Your Lordship.
By consent of learned counsel for the parties. List this appeal and miscellaneous application. Not 2 weeks. On 20th August. No, not 20th August. 18th August. You are getting 2 weeks anyway.
Highly obliged,
Yes.
Lordship.
Much obliged.
Number 9.
May it please your lordships. Lordship, Senior Counsel Mr. Paul is currently having some personal difficulties. I'm praying
What?
for Senior Counsel Mr. Paul is having some personal difficulties, your lordship.
Not
So-
today.
Not today, lordship. I'm praying for a week's time, lordship.
Sorry?
I'm praying for a week's time, lordship.
Why? For the petitioner?
For the appellant, lordship.
Hmm?
For the appellant.
Yes, for the appellant.
Lordship.
On the ground of Mr. K. Paul, learned senior advocate for the petitioner. On the personal ground, this appeal is adjourned till 11th August.
Obliged, lordship.
Number 10.
Much obliged.
Please, Lordship.
Item number 1.
May I please, Your Lordship? Your Lordship, I have been instructed by Mr. Pathak to appear today. I am seeking for 1 week time to file my wakalatnama and for instructions, Lordship.
Who is Mr. Pathak?
Sorry, Lordship.
In fact, I was only seeking a very small, if there are no objection, my lord. My lordship constituted a board for medical examination, my lord, of the respondent. You might draw lordship at page 10 of the review petition, my lord.
That is I matter,
I matter, my lord. But the lordship is because there's one private medical practice, my lord. That is, I was just seeking some modification of that. If a doctor from Nigrims, my lord, there are medical college in Shillong, my lord, would be substituted, my lord. Only that much, my lord.
This is your application, Union of India.
My lord.
What is the modification you are seeking?
But my lord, if kindly comes to page 10, my lord.
Yes.
Page 10, your lordship is directed. I hereby constitute a medical board as follows. 1 medical specialist in the field from the state government, my lord. We have no objection to that. 1 medical specialist to be nominated by the Director General. This is also okay, my lord. 1 shall be a specialist medical private practitioner to be agreed upon by the Director General and the state government's health service. My lord, instead of this, my lord, I was only praying, my lord, if a doctor from Nigrims, my lord, Nigrims is a central medical college here. Only that much modification, my lord. Because inducting a private doctor, we're finding a little difficult, but there has to be concurrence between the center and the Assam Rifles, so state and the Assam Rifles.
Okay. I is state. II is central.
Assam Rifles, my lord. Third is a private. Instead of private, I was only
1
praying
medical specialist to be nominated by the Director General. Director General of?
Assam Rifles, my lord.
So he could be both government or private.
My lord, 1 is from central government, 1 is from Assam Rifles, my lord. Because Assam Rifle has their own medical establishment. They have their own hospital, my lord. So from there they'll nominate 1. 1 is from state government, my lord. And third, I was praying for if it can be from Nigrims, my lord.
You have a medical service in Assam Rifles?
Yes, my lord. We have our own hospitals, my lord. They're called composite hospitals, my lord. In fact, there are 3 or 4 hospitals, my lord.
Two should be Director General for medical service attached to Assam Rifles.
My lord.
And III Nigrims.
My lord. This will expedite the thing. This is in their interest also, my lord.
Your Lordship, I was sent to seek just 1 week time for
What?
instructions. For instructions upon their...
No. Please take them for this. By this you do damage to your client. You should stand on your feet here and now, understand and agree. I am seeking 1 week's time. For what purpose you will seek 1 week's time?
No,
You should independently take a decision. Forget about your senior. And if your senior asks you, you tell him the court did not listen. Finished. I asked for time on your behalf. Why he is asking for time, we know.
Yes, sir.
And the court refused. Paragraph. This is a very innocuous application made by the Union of India for a minor modification of our judgment and order dated 2nd April 2025. Learned advocate for the respondent prays for time to file the Vakanatnama and to properly instruct her senior in the matter. Paragraph. I am of the view that no such exercise is necessary The matter has been pending for a long time and disposed of by this court finally on 2nd April 2025. It is high time that the petitioner gets the benefit of the order upon its minor modification as prayed for by the learned Deputy Solicitor General, Dr. Mozika, on behalf of the applicant, Union of India. Paragraph. Considering the scheme of medical examination in Assam Rifles, there is a minor mistake in constitution of the medical board in the said order dated 2nd April 2025. Next, the part of the order in the second last page of the order sheets, quotation, I hereby constitute ... panel, unquote, is modified by inserting the phrase quotation from the panel of doctors attached to Assam Rifles. No, panel of doctors in the service of Assam Rifles. Unquote, after general in the subparagraph II, next line, let quotation specialist medical private practitioner be deleted and replaced by quotation, a specialist doctor No, shall be a specialist, surgeon stroke physician, unquote. No, the physician in the service of Negrims, Shillong, unquote. Therefore, the reconstituted paragraph of the said order shall be colon what have I said against two?
It will have been free from the panel of cluster in the service of authorized professional, medical, private practitioner, integrated and replaced by a specialist surgeon class physician in the service of Negrims, Shillong. Therefore, the reconstituted paragraph of the said order shall be followed.
You bring your book. Just sit down. You bring your book. Can you just read out what you have written? Huh? Sorry, medical in II. No, first. Okay. Specialist. No, this is 3. Before that, medical specialist to be nominated by the Director General from the in Assam Rifles. Okay. Now you just take down. II should be reconstructed as 1 medical specialist to be nominated by the Director General from. No, you have to face me, otherwise it will not do. So then you come here. You can stand. Specialist. Oh. Then what have I said? From the medical service of Assam Rifles. A specialist, I think I've said surgeon stroke doctor to be approved by the Director General of the State Government Health Service in the panel from Negrims. One medical specialist.
But the third one can be even nominated by the director of Negrims.
Sorry?
Director Negrims can nominate that, my lord. Third one.
So this reconstruction will be this, huh? One medical specialist in the field from the state government health service to be nominated by the Meghalaya government. Okay? 2, one medical specialist to be nominated by the Director General from Assam Rifles. Okay? And 3, one shall be a specialist doctor stroke surgeon. Eye surgeon.
Your Lordship, this is not the eye matter, Your Lordship. It is the other matter. The eye surgeon, this is not eye surgeon, Your Lordship.
Surgeon. To be nominated by the Director of Negligence. So in the first part of the order, you have to write that in II, this is to be added. In III, this is to be added or subtracted. This part is to be omitted and replaced by this. First give that statement. Then reconstituted part of the order is this. After this addition, deletion. To do it, then I am there to correct it. Compliance is to be effected within 2 months of communication of this order. The order dated 2nd April is modified accordingly.
Number 2.
This is an appeal against the land acquisition award, my lord, passed by the lower court, my lord.
Yes.
But these are here land was acquired by the central government, my lord. And certain award was passed by the collector, my lord. Against that, the respondent filed a section 18 reference before the learned trial court, my lord. And learned trial court has enhanced the compensation, my lord, from 160 rupees per square feet to 300 rupees per square feet, my lord.
And the district judge has found that it is okay.
Well, the district judge is enhanced, my lord, from 160. Collector is given 160 rupees, my lord, per square feet. The district judge has enhanced it to 300 rupees per square feet, my lord.
Yes.
We have come against that, my lord. The paper books have been filed, my lord. The matter is otherwise ready for hearing.
So what wrong has the district judge done?
My lord, our case is, my lord, that the district judge relied on 2 documents, my lord. One was an exemplar sale deed, and second was a valuation certificate given by the collector, my lord, by the office of the deputy commissioner, which was of 200 rupees, my lord, and the valuation certificate was just two years back, my lord. 2005, the valuation certificate was issued, my lord, and the land here was notified under section 4 in 2007. So our case is, my lord, within 2 years, my lord, the price of land cannot go up from 200 rupees per square feet to 300, my lord. Because there is Supreme Court decision which says that at the most annual enhancement can be taken at 10 to 12%, my lord. That is our submission. So here the difference was only of 2 years. Secondly, of course,
what enhanced in 2 years? What valuation enhanced?
My lord, what happened, my lord? 2005, they produced a document issued in 2005 by the Office of the Deputy Commissioner, my lord, saying that the value of the land in that area is 200 rupees per square feet, my lord. Here, my lord, the land acquisition process was initiated in September 2007. So it was a gap of only 2 years, my lord. Now the London Trial Court has relied on that document and enhanced the compensation from 160 to 300 rupees, my lord.
No, the Deputy Commissioner has also enhanced his valuation.
They only issue a valuation certificate. I'll just take your lordship to the valuation certificate, my lord. For a moment, my lord. Page 131, my lord, kindly comes on.
My lord, with your lordship's permission,
Yes.
I'm appearing for the respondents,
Yes.
the claimant. And the first and foremost thing, if your lordship permit me, I just want to bring it to lordship's notice. Deliberately, the appellant did not appear before the reference court, and that your lordship will find at 198 of his appeal memo. This is an admitted position.
That is admitted position, my lord. My lord, here what happened, my lord, when
Not only
the
that, what is important is he has attributed something to the collector, saying that he was hoping something. If your lordship will kindly turn to page 198, paragraph 1 is at page 199. The relevant of paragraph 1, your lordship will find the relevant portion which I wish to bring it to your lordship's notice is at 200. The last line. The last line, my lord. At page 200, paragraph 1, just above paragraph 2. The case was, your lordship, the case was not contested by a special bureau. They are the appellant here, though they received the notice from the court initially. Then your lordship will come to page 202, my lord. 202, paragraph 4. Paragraph 4.
Yes.
Paragraph 202. Paragraph 4. Page 202, my lord. Paragraph 4, I am pressing before lordship. That initially notice was received by office of the appellant from the court of the learned special judicial officer. This is the reference court, Shillong. However, the appellant did not contest the case in bona fide belief that the collector, respondent number 2, being the statutory authority, has the primary responsibility to contest the case. Now, this is the state of affair, my lord.
well, this is admitted position, my lord. When a reference was
From an ex parte decree also an appeal lies. So let us see what he has to say.
Yes, yes. Let him, after he finishes, then I will, my lord, begin.
Of course.
The subject to what you see.
my lord, page 131, my lord.
Yes.
Is a land valuation certificate, my lord, issued by additional deputy commissioner. Page 131, my lord, 131.
Yes.
So, my lord, this is dated 12th August 2003, my lord. A land valuation certificate. With reference to your application quoted above, you are hereby informed that the land valuation in respect of the land at Lau Usib Nongtumai is valued at rupees 200 only per square feet. So this was dated 13th August 2003, my lord, 12th August 2003. And thereafter, my lord, and to the next page, my lord, page 132.
No, you tell us that on this basis any decree was passed.
My lord, basically on two documents, my lord. This was one document, my lord. And second is an agreement to sell at page 132, my lord.
It's all right. This is 200. So how did the district judge value it?
Well, district judge referred to this document, my lord, and the next document also.
Yes.
Next document is an registered agreement to sell, my lord.
Yes.
Valuing the land at 300 rupees.
Yes.
But for a smaller plot of land, my lord. My lord will find at page 137 the plot size was at page 137, my lord. Plot size was only 4,734 square feet.
No, this sale agreement is page 132.
My lord, page starts at 132. I am referring to page 137, my lord.
So here it is 200.
In the sale agreement is 300 rupees, my lord.
No, in the
land valuation certificate was 200.
The same land.
My lord, this is not same land. It's
neighboring area.
A neighboring area, my lord.
And this is 300.
This is 300, my lord.
Yes.
Here, my lord, at page 137, we'll see the area here was only 4,734 square feet, my lord. Is page 137 on the top?
4,700?
4734.
Okay.
4,734, my lord.
And this 200? 200?
200 is a general valuation given by the office of district collector, my lord.
Yes, on these two documents, he has valued the land.
My lord.
At how much?
By 300 rupees.
By 300?
My lord.
So why you think 300 is excessive?
But our case is, my lord,
3-4 square feet.
My lord.
What is the date of the sale agreement?
Sale agreement is dated, my lord.
19/9/2017 is section 4 notification, my lord. 2007.
Sale agreement is 29/8/2006, my lord. 29th August 2006.
All right. We'll hear it again tomorrow.
Tomorrow.
It's all right, sir. Tomorrow.
Well, tomorrow, my lord, I have in Guwahati some personal matters are there. I'm extremely sorry. This week, my lord,
I think this can be finished up in about half an hour.
Yes, my lord, it's a short matter.
No, my lord, with your lordships, this thing, it won't take time, I'm sure. But my lord, only this week, if your lordship can kindly accommodate me, your lordship can take it up on 11th.
All right.
On 11th, if my lord can take it up.
11th Monday.
I've heard Dr. Mozika for the appellant.
I'm DK Mishra, my lord, senior advocate.
No, I've said Dr. Mozika.
Yeah. No, I'm just saying now you have your lordship.
No, I know your name. You are very senior and
Well,
to list this appeal for further hearing on 11th at 12:45 or after exhaustion of the list of the division bench, whichever is earlier.
Well,
Dr. Mozika, I don't think there is any such patent error that the court will interfere in first appeal.
Well, here actually what happened, my lord, I'll just be very candid. The department was not even aware, my lord, that there is some proceedings are pending. Officers come and go, my lord, and this was pending for almost 15 years. Suddenly, when they saw the award decree from the court, 10-12 crore rupees they have to pay, they're shocked.
Because in these cases, the Supreme Court has also said that unless the appellate court finds some palpable error, gross irregularity, or perversity in the fact-finding process of the court below, it should ordinarily not interfere. This is true in the case of injunction orders, Also in the case of regular appeals.
It's true, my lord. I appreciate it, my lord.
But 200, 300, what?
300 rupees. But only what happened, my lord? They were not aware that there's any such case is pending, my lord. Because maybe notice was issued 15 years back, my lord. I'm not trying to justify, my lord. They should have taken care of that. But suddenly, when they received a notice from execution court, my lord, that they have to pay 12 crore or 10 crore rupees something, then
you not having contested the matter,
my lord.
so the rule of estoppel also operates against you. You will be estopped from now contesting the valuation at the appellate stage. All these hurdles are there. I think
Are there,
next
I'll just place few facts, my lord, on next day. I'll not take much time.
next Monday.
Deeply.